All right. Hello, everybody. Welcome. Welcome to the webinar, this webinar on pass-through expenses. We have been, many of you are, I see a lot of familiar names and faces. We're going through the AIR CRE lease, section by section, paragraph by paragraph. And today's focus is paragraph 4.2, which is entitled Common Area Operating Expenses. And just to give you a little bit of background intro on myself before we begin, I've been a real estate lawyer for 20 plus years. Just muting all the participants, but feel free to unmute if you have a question along the way. Real estate lawyer for over 20 years. In 2017, I founded Consensus Legal. We focus at Consensus Legal on commercial leasing and commercial sales transactions. AIR CRE Contracts, you probably have joined because you use them, you want to learn more about them. My perspective, they're incredible contracts, well drafted, it makes transactions easier, and they are the best form contracts out there, in my opinion. And as many of you may know, AIR CRE has expanded its contracts to nearly all 50 states, plus the District of Columbia. So it's available for out-of-state transactions as well. For this webinar, I have a few topics I want to cover and discuss with you. Along the way, if you have any questions, feel free to unmute. I'll try to check the chat box along the way as well. And then I'll stay on for about 20 minutes for Q&A. Some disclaimers. AIR Forms Practitioner is not affiliated with or sponsored by AIR CRE. I'm not providing legal advice during these webinars. It is for education and discussion purposes. Okay, with that, let's jump into common area operating expenses, paragraph 4.2. During this webinar, we're going to focus on two leases in particular, the multi-tenant net lease and the multi-tenant gross lease. And I'll be sharing my screen and we will be going through those leases. But before I share, we'll start with the net lease, but before I share the net lease, generally speaking, there are three buckets of pass-through expenses, as many or perhaps all of you know. There is the CAM bucket, common area maintenance fees. That's the first bucket of expenses lessors pass through to lessee. There is the property taxes bucket. That's the second bucket, we'll say. And the third bucket is insurance expenses that lessors pass through to lessees. And in the multi-tenant net lease, like a typical net lease, lessor can pass through expenses that fall into each of those three buckets. So I will share the multi-tenant net lease. Okay, 1 second, actually, just moving that up here. Okay, so hopefully all of you can see the lease on your screen. And 4.2, common area operating expenses. This is as I said, the multi-tenant net lease. So 4.2a is the key provision here. And common area operating expenses, this is the definition. It's defined as all costs relating to the ownership and operation of the project. That's a very broad language, right? When it says all costs. And notice it says including but not limited to the following. So it gives a list. Here's Romanet 1, 2, 3, all the way to 10. So it gives a list of 10 items that are specifically permitted, expressly permitted to be passed through from lessor to lessee. But it's not an exhaustive list because it says including but not limited to the following. So that's the first point that I wanted to mention. Now, this first of the list of 10, This first item, item 1, covers common areas, okay? Now, under 4.2A1, lessor can pass through the costs of operation, repair, excuse me, and maintenance of the common areas. But look at this. This is a key provision for lessors and lessees. It says, and if necessary, the replacement of these common areas. So under the multi-tenant net lease, lessor is permitted to pass through not only common area expenses relating to maintenance and repair, but also related to replacement. So what's an example of replacement? A big one many of you know about is roof replacement, right? If the roof needs to be repaired, it needs to be replaced, excuse me, under this net lease, lessor can pass through the cost to lessee. And I'm going to jump ahead just a little bit down to number 9 here. This discusses something like the roof. Lessor can pass through the cost of any capital improvement to the project. But what does it have to do? It can't charge it all in 1 month or 1 year. It passes through the cost over a 12-year period. So lessor wants to replace the roof January 1, 2025, let's say. It has to amortize it over a 12-year period. So if lessee is only going to be there for 3 years out of the 12 years, lessee would only have to pay 3/12 or 1/4 of lessee's share of that roof replacement. So I'm going to pause. If you have any questions, feel free to chime in along the way. Otherwise, I will continue. So, and I'm just checking the chat box. Okay. So that's item 1, operation, repair, maintenance, but also replacement of common areas can be passed through. Let's go to item 2. In item 2.
Real quick, is the replacements paid monthly, right?
Yes. Typically, the lease allows lessor to charge estimates, and lessors will generally charge monthly estimates. That's right. You don't have to bill it on a yearly basis. That's correct, James. Item 2, utilities, common area utilities can be charged. So lessor can pass through the cost of electricity, lighting for the parking areas, for example. Utilities for a particular premises that's separately metered, of course, lessee pays that separately. But this is common area utilities. Lessor can pass through this. Item 3 allows lessor to pass through the cost of trash disposal, pest control services, but importantly, please note this one, property management costs. So lessor, if it's paying 3% property management fees, it can pass through that cost. Another note here, there's no cap in the AIR CRE lease on the property management fees that can be passed through. So whatever lessor incurs, it can pass it through. Item 4, this is a key one. Very few lessors, in my experience, use it, but this is a very important one. Reserves set aside for maintenance, repair, and or replacement of common area improvements and equipment. So that example I talked about at the beginning of a roof replacement, lessor does not have to wait until it actually replaces the roof to begin passing through the cost of a roof replacement to lessees. It can build up reserves. So if lessor is going to replace the roof in 5 years, let's say, it can start building up reserves for that expense. And let's say that in that scenario where the roof replacement is going to happen in 5 years, let's say that a lessee will only be there for 3 years. Does lessee have to pay those reserves during their 3 years, even though the roof is not going to be replaced for 5 years? And the answer is yes. Under this paragraph, reserves, that's the part of the point of it.
One question related to that.
Pass that through. Sure, Frank.
So let's say that they're going to be there 3 years and they still have to pay the reserves. Let's say, for instance, for some reason, the landlord does not replace the roof, the parking lot, whatever it is, before the person leaves. Is that refundable then?
No, it wouldn't be refundable.
So then a landlord can actually take that paragraph and take as much money as he wants, and he doesn't have and for the future, and he could repair something in 10 years, and if a guy leaves in 5, he doesn't have to give him back his money.
Well, yeah, I mean, you cannot in any contract, you have to act in good faith. There's a covenant, implied covenant of good faith and fair dealing, and you can't commit fraud and those types of things. But there's practical limitations on that, and we can get into, if you have more questions about that, we can get into more detail in the Q&A.
Okay.
But a very good question. Thank you, Frank.
Real
Next
quick, it would seem to me that provision was for, let's say you bought a property on, I'm just picking, and I may have this wrong, but let's say on January 1 of 24, and the roof, it's going to need to be replaced in 4 years. So you're beginning a reserve for those 4 years where that tenant's enjoying the deterioration of that roof. I mean, basically, I think that's what it's for, but maybe I'm wrong. It feels like it anyway.
No, I think you're exactly right, James. That is the concept. It's definitely not to allow lessors to profit in an unreasonable or unfair way. It's that is the concept. And a lot of, national tenants, James, you may have seen it also. This is one of the common provisions I see stricken when dealing with, bigger tenants or national tenants. They don't like publicly traded companies. They don't like reserves. But you're right. That's the rationale, James, for having it. The next item in 4.2a, item 6, is the second bucket we talked about, real property taxes. Lessor can pass through the real property taxes it incurs. Now, what if during the lease term the property is sold and it was a low tax basis and the real property taxes went up 6 times? Can lessor, under the AIR CRE lease, the new owner, can it pass through those increased property taxes to lessee? And I see Mark in the chat box. Yes, you're right, Mark. There is no Prop 13 protection in the AIR CRE lease. Lessor can pass through that cost. I think this reflects market. Almost no lease forms that I've seen have Prop 13 protection built into a lease template. The next item, item 6, the cost of premiums for the insurance maintained by lessor. This is the third bucket. Lessor can pass through insurance premiums to lessee. Item 7, if there's an insured loss, some type of casualty, lessor can pass through the deductible. Item 8, lessor can pass through professional fees, auditors, accountants, and attorneys' fees, those costs relating to the maintenance, repair, replacement of the project. So those items can be passed through. We talked about item 10, capital improvements can be passed through. And before we move on from the net lease, I'll just point out one more item, which is, I would call it the no double dipping provision, which is paragraph E. And what this says, common area operating expenses shall not include any expenses paid by any tenant directly to third parties, or as to which lessor is otherwise reimbursed by any third party, other tenant, or insurance proceeds. So the AIR CRE lease is just making sure that, you know, a lessor cannot double dip and charge something to lessee which it's been reimbursed or received compensation for. So I will stop there for the moment before we go through the gross lease. And the gross lease, we're going to go through a little quicker. You know what? Because we're just a little bit behind, I will just move on to the gross lease, and I will look for questions. I see some questions in the chat box. I will try to address them in the Q&A. That's okay. So let me pull up and share the gross lease. I'm actually going to put these side by side because I want to compare them. Hopefully you all can see it side by side. Okay, so the net lease is here on the left. And the gross lease is on the right. I think you all should be able to see it. Oh no, is it working? Okay, I think it's working. Okay, so we talked about, and the gross lease in general, let me address that. So the gross lease in general, we have the AIR CRE multi-tenant gross lease is what is often referred to as an industrial gross lease. So those three buckets we talked about, common area maintenance fees is the first bucket, property taxes is the second bucket, insurance expenses is the third bucket. With respect to buckets 2 and 3, property taxes and insurance expenses, there's a base year. So lessee is only going to pay increases in property taxes and increases in insurance expenses over the base year. The base year is basically, you know, the 12 months before the lease was executed. There's slight differences that we won't get into, but in general, property taxes and insurance expenses, as they increase, lessee is only going to pay those increases. Now, with respect to the first bucket, CAMs, under the multi-tenant gross lease, lessee is going to pay all of the CAMs. So there's no base year for the CAMs. It's not an office lease. It's, you know, oftentimes referred to as a industrial gross lease. Okay, so let's get into 4.2 in the gross lease. On the right side is the gross lease, multi-tenant gross. On the left side is the multi-tenant net. I mentioned that in this net form, it's very inclusive. All costs relating to the ownership and operation of the project, including but not limited to, and it gives a list of 10 items. The gross lease uses different language. It says the lessor can charge to lessee the following costs relating to the ownership and operation of the project. So there's a list of 10 items that's very similar in the gross lease. It's similar to the net lease, but it says these are the only costs that lessor can pass through to lessee. And as opposed to the net lease, which has, it says all costs and gives an example. The 10 items are examples of what lessor can pass through to lessee. So in this gross lease, let's go through this list of the 10 items. There's one big difference in item 1. So item 1 in the net lease, we talked about its operation, repair, maintenance, and replacement of the common areas. Flipping back to the gross lease, it's costs relating to the operation, repair, and maintenance of the common areas. But look here, it says, but not the replacement of the common areas. So this is a subtle but very important point. Most lawyers that use the AIR CRE contracts don't know this distinction. In the gross lease, lessors cannot pass through the cost of replacement of the common areas. So that roof replacement that we've talked about, lessor cannot pass that through to lessee under the gross lease. Even though there's no base year for the CAMs in the gross lease, this is one of the key differences in the CAMs, that first bucket that lessees are responsible for. This 4.2A1 refers to subparagraph E. So let's just go down to subparagraph E because this clarifies it. Subparagraph E clarifies it. Common area operating expenses shall not include the cost of replacing equipment or capital components, such as the roof, foundations, exterior walls, or common area capital improvements, such as the parking lot paving, elevators, or fences that have a useful life for accounting purposes of 5 years or more. Okay, so that's one key difference, key takeaway from this webinar, hopefully, is that distinction. Let's go through the rest of the items, the 10 items in the gross lease. Item 2 is similar. Lessor can pass through, it's the same. Lessor can pass through the cost of utilities for the common areas. It can, in item 3, it can pass through the cost of trash disposal, pest control services, and the same thing, property management. Okay, so that's the same. Let's get to item 4. In item 4 of the net lease, you can pass through, lessors can pass through reserves for not just maintenance and repair, but also replacement of common areas. We talked about the roof example, building reserves for the roof replacement. Now let's flip over to the gross lease. Under the gross lease, lessor can pass through reserves for maintenance and repair of the common areas. It doesn't say replacement. Since lessor, under the gross lease, cannot pass through the cost of replacement of a roof, it makes sense that it cannot build up reserves for replacement of a roof. Item 5 here, in the net lease, lessor is responsible for all, lessor can pass through all property taxes, real property taxes to lessee. In the gross lease, we talked about there's a base year for taxes. So it says here, lessor can only pass through any increase above the base real property taxes. In the net lease, item 6 is lessor can pass through the cost of the premiums for the insurance. But under a gross lease, we talked about a base year for insurance. So let's flip over to the gross lease, and it says lessor can only pass through any insurance cost increase. Not number 7 is similar. Lessor can pass through the deductible for an insured loss. 8 is similar. Lessor can pass through professional fees, auditors, accountants, and attorneys' fees. So I will, and the double dipping provision is also here in the gross lease. It's subparagraph F in the gross lease. It's subparagraph E in the net lease. And the reason is the gross lease added the exclusion for replacement of capital items. So it's a pretty dense seminar, dense content, these two 4.2 in the net and gross leases. I will stop there and open it up for questions. And I'll also try to catch up with the chat box.
I have a question whenever you get a chance.
Sure, go ahead, Frank.
So where is the delineation, the line between, let's take a parking lot paving, for instance, between maintenance, repairs, and replacement? A lot of times a parking lot doesn't just need to be slurried, which is definitely maintenance, but it also needs to be dug out because of major alligatoring and replaced. Portions need to be replaced. Since they're being replaced, does that consider replacement of the whole capital improvement or still maintenance?
It sounds like that to me. It sounds like that constitutes replacement. I mean, is
there a 50% or something like that? If you replace 25% or 50%, then it's replacement, or versus maintenance, or if you replace 10% because of being worn out, does it consider maintenance? I mean, that's a tough line.
It is a tough line, and there is no specific definition or delineation. But it's interesting, Frank, I think the reason you mentioned 50% is because elsewhere in the AIR CRE lease, there is a 50% threshold. And let me just go to that provision. This is in 7.1D. So 7.1D does define replacement, but this is different. Let me just clarify. This is different from 4.2A. This does not apply to 4.2, okay? What this applies to are things like HVAC equipment. In 7.1B, it refers to HVAC equipment, for example. So if something like the HVAC in a premises needs to be replaced, then lessor can pass through the cost and amortize it over 12 years. And there is this 50% threshold that you mentioned. So if the cost is going to be 50%, if the cost to repair is going to be 50%, then the lessor can replace the item and pass through the cost to lessee. So I think that's where you got the 50%, but you're right. If we go back to 4.2, there can be disagreement, and you get when there is disagreement, you have to rely on custom and industry practice, and you just have to do your best to kind of figure it out between the parties. I know that's not a great answer, but the alternative is having a lease that just gets longer and longer and longer, and then you lose some of the efficiency of the AIR CRE contracts.
Right.
Usman, this is Bob. I got a question on the if a landlord has internal property management company people and or inside attorney, if you will, or accountants, can they actually take those costs and pass them through versus outside third-party costs that are provided by property management and accounting, et cetera?
That's a good question, Bob. It doesn't specifically say, like some commercial leases will say accountants' fees, attorney's fees paid to third parties can be passed through. I haven't thought about that issue. This says auditors, accountant, attorney's fees and costs. So I don't know, maybe a lessor could argue that, but there is potentially some ambiguity here. So I haven't seen a lessor try it, but maybe someone will, maybe someone has.
Okay, thank you.
There's some ambiguity, yeah. And I'm going to the chat box. Edith asks, is the share the percentage of occupancy? Yes. So let me just clarify that. That's a good question, Edith. When we talk about, for example, replacement of a roof, if it costs $120,000 to replace a roof, it's going to be amortized over 12 years. So it's going to be $10,000 per year. And if each lessee isn't going to pay $10,000, this is a multi-tenant lease. So lessee is only going to pay its share. So if all of the lessees collectively are paying $10,000, and if a particular lessee has 10% of the project, then that lessee will only pay 10% of the $10,000 each year, or $1,000. So thank you for that clarification. When I use lessee share, that's what I mean. Matt asks, same for multi-tenant lease gross. I'm not sure, that question I think was asked during the presentation, so I'm not sure what that was referring to. Mark asks, would that also include repaving for the parking lot? I think we discussed that. Ty asks, what capital improvements can be passed through immediately? Well, if it's a capital improvement, and let me just share it again. If it's considered a capital improvement, it does have to be passed through over 12 years. Whether some items and some replacement of items can be considered, not a capital improvement, that's, probably a case-by-case analysis. Ben asks, I don't know if I answered fully your question, Ty. There's different kind of standards for capital improvements. Sometimes some leases will get into detail on it. They'll get into looking at whether they're considered, capital improvements for accounting purposes, for tax purposes. There isn't a clear definition in the AIR CRE lease. So it's kind of a case-by-case situation. Ben asks, what if it is a multi-tenant, but replacement item only affects one of the tenants? For example, let's say a power panel needs to be replaced and it only powers one of the tenants. Does it pass through to all the tenants or just the tenant the power panel affects? Yeah, that is a good question. And let's go to the multi-tenant net lease. Let me share this once again. So I think the answer is in B here, Ben. Any common area, is this the one? Yeah, I think this is the one. Any common area operating expenses that are specifically attributable to the unit. So that power panel example, if it's only attributable to your unit, then it shall be allocated entirely to your unit. So it would not be passed through to all the tenants there. Victoria, regarding the 12-year amortization passed back in CAMs, can new tenants coming in be charged as well? Say they come in a year after. Good question, Victoria. Under that reserve provision, if the reserve provision well, regardless of whether the reserves provision has been deleted, yes, it can be amortized over 12 years, and yes, new tenants can be charged. And you know, many of you are brokers, and you get estimates for your clients of and sometimes breakdowns with specificity of the pass-throughs. And I've seen it. I've seen that frequently include, you know, capital expenditures that are being amortized. So yes, Victoria, it can include that. Good question, Ty. I don't think so, but let's talk about that offline. You know, things like unlawful detainer passing through, that type of thing. Justin, can the tenant ask for proof receipts for work done to justify their increased OpEx? So we didn't talk about the mechanics of passing through expenses. It's 12:38. Let's get into that just a little bit. We have a couple minutes. Okay, so the mechanics of passing through the expenses are in D. So lessee's share of common area operating expenses is payable monthly on the same day base rent is due. So if base rent is due on the 1st, common area operating expenses are due on the 1st. The second sentence gives lessor the right to estimate common area operating expenses. This next sentence gets into timing. Within 60 days after written request, lessor shall deliver to lessee a reasonably detailed statement showing lessee's share of actual common area operating expenses the preceding year. Now, Justin, your question was more than that. You're talking about more detail, invoices, receipts, that type of thing. This does not provide for or require lessor to provide invoices. It's a statement that's required. So the answer to your question is no, lessor does not have to provide it under the terms of the lease. And then the rest of this, I think, gets into reconciliation of estimates. And let me just pause before we end the Q&A and the recording, and I'll get to, there's some additional questions in the chat box, and I'll get to them after I stop the recording. But before I stop the recording, I just wanted to get into one item which is important for many of you out there who are involved in representing lessees. And that is, how can lessees limit their exposure for pass-throughs? And many of you are brokers, you negotiate these things sometimes in the LOI. One common way that you can limit exposure if you're a lessee is through Prop 13 protection, of course. And Prop 13 protection, even in this market, which is moving more in favor of the tenant, I'm not seeing that much Prop 13 protection. So, but of course, that's one way to limit exposure, particularly if the project has not been sold recently. It has a low tax basis under the net and gross lease. If there is a change in ownership and the property taxes increase dramatically, lessee is responsible in both situations, net and gross lease, because as we said, under the gross lease, the lessee is responsible for increases in taxes. So it includes an increase resulting from a change in ownership. The other way lessees frequently try to limit exposure is through a cap on increases, annual increases in common area operating expenses. We see frequently a 5% cap that lessees' common area operating expenses cannot increase by more than 5% from the prior year. Another way lessees try to limit exposure is through caps on controllable operating expenses. So, certain defined controllable operating expenses, those can be capped, such as, a 5% cap. So those you probably have seen them. Those are some ways that lessees can limit exposure. Another common way to just it doesn't legally limit exposure, but it can help lessees is to get ahead of time before signing the lease a breakdown of the common area expenses that lessor passes through. And I think the more detail a lessee gets, the more it gets a sense of how lessor is operating the project. So with that, I will end the recording. I will try to answer the additional questions in the chat box, but I just wanted to say thank you so much for your attention. This was a dense webinar. I know there was a lot to go over. Hopefully you found it helpful. It has been a pleasure. I will end the recording, but I will stay on for some additional questions. Thank you all so much.